Welcome everyone to our webinar on redundancies and restructuring, understanding your employer obligations. My name is Saeidul Haque and I'm a senior associate in the employment and health and safety team at LegalVision. So before we begin, a couple of housekeeping items before we begin slides. So we will be recording this session today and you will be emailed a copy of it. So if you miss anything, you will have a chance to look back later today. We'll also be taking questions at the end, so please submit your questions in the Q&A box, and I will try and answer as many of them as I can at the end. Finally, there is a survey at the end of this webinar, and I would be grateful if you could complete this to give us any feedback. For the next 48 hours, you are also eligible for a free consultation with LegalVision to discuss how we can help your business. To claim this consultation, please provide your contact details in the survey at the end of this webinar. So a quick poll question then, just before we get going into the main contents. So what is your biggest challenge when managing redundancies and restructuring? You should see a question box pop up in a moment. So the answers to that question would be confirming a genuine redundancy, preparing a business case, consulting and notifying employees, reducing legal risk and termination, managing final pay correctly, or nothing yet, just here to learn. So you should see that pop up now. I'll give you guys a couple of minutes just to answer. So again, I'll just read the question out. What is your biggest challenge when managing redundancies and restructuring? Is it confirming a redundancy case? Is it preparing a business case? Is it consulting and notifying employees? Reducing legal risk and terminations? Managing final pay correctly? Or nothing quite yet? You're just here to learn. So I'll give you a minute or so. So just waiting for everyone to answer the question and then we'll get moving. Okay, excellent. So thank you all for completing the poll question. So it seems like there's a bit of a mixed bag in terms of what most people find difficult. Confirming genuine redundancy seems to be a popular one. Same with consulting, notifying employees, and reducing legal risks as well. Excellent. So thank you all for participating in that. So we'll get going with the content today. So today what we'll be discussing is what is a genuine redundancy. We'll be discussing preparing a business case, how to notify and consult with affected employees, the risks of terminating employment, and also final steps and pay. At the end of this webinar, I will be answering some of your questions, as I say, so please submit them throughout this webinar through the chat function, and I will answer as much as I can at the end. If I don't get to your question, please leave your contact details at the end of this survey when the webinar ends and claim your complimentary legal consultation and book a call with me. So if we get going with the main concept today, then, so what is a genuine redundancy? So generally the term redundancy is a term used to describe a situation which an employer decides to reduce the number of its employees either within the business as a whole or within a particular site, business unit, function, or job role. Now, redundancies usually occur when a role is no longer required and should only be considered if all or part of a business is closing, changing location, or if there is a change to the type or number of roles required to do certain work. Businesses may generally consider making redundancies for various reasons, and that may include internal reorganization, such as a restructure. It could be a recession or other economic pressures like the cost of living crisis that we have at the moment. It could be a downturn in business, or it could just be other changes in the business's operational requirements. Now, redundancies are a fair reason to terminate an employee's employment, but for a redundancy dismissal to be fair, you must establish that firstly, the redundancy was the real reason for the dismissal, and secondly, that you must act reasonably in all the circumstances in treating redundancy as a reason for dismissing the employee. So this essentially just means that you're required to follow a fair process before any redundancy is made. Generally speaking, employment law doesn't interfere with an employer's freedom to make business decisions, and an employer will not be required to justify its reason for making redundancies. It is, however, worth noting that if a matter is escalated to an employment tribunal, then provided that the tribunal is satisfied that the redundancy is genuine, then they will usually not look behind the reasons and the facts to see how the redundancy situation arose. But if an employee alleges that redundancy was not the real reason for the dismissal and that there was, in fact, a different reason, then the background to the redundancy may be subject to scrutiny. It is therefore important to ensure that any redundancy is genuine and very well documented from the outset. So this takes us on to preparing a business case. So a business case is essentially a document that's going to form the backbone of the redundancy and the consultation process as well, and it will document the need for redundancies as well. So the business case can be used to demonstrate that a redundancy was actually genuine and necessary of challenge, particularly in relation to any sort of tribunal claims. And this approach also helps to maintain trust and fairness in the workplace during what is often a difficult time for everyone involved. Now, a business case should cover many elements, and it should firstly confirm the reason or the reasons that a compulsory redundancy or redundancies are being considered. It should set out the evidence that supports a proposal for redundancy, so that could be financial evidence, for instance. It should confirm the alternatives that are being considered to prevent redundancies. It should set out the proposed changes to the workplace structure, so a before and after of your organization chart. It should confirm who will be chairing and or leading the redundancy process, and it should also contain the details of those affected by this process. And that would include things like an employee's name, date of birth, salary, so on and so forth. Now, consultation is a very important part of the redundancy process, and it's important because it is there to demonstrate the fairness for any dismissal for redundancy and the different rules for consultation depending on the number of redundancies being made. The purpose of consultation then really is to avoid or reduce the number of compulsory redundancies that need to be made, and it should also entail a frank conversation about the redundancy and certain elements such as the reasons for the proposed redundancies, the number and categories of employees who may be affected, the proposed method of selecting employees for redundancies, proposed method of carrying out the redundancy process, including the timescale and the calculation of the redundancy payment. So all of these elements are essentially elements that you can cover off in the business case, which is why it is such an important part to consider. Now, for individual redundancies or small scale redundancies, so this is fewer than 20 employees within a 90-day period, there is no set time frame for consultation, but it should be meaningful and allow for constructive and genuine dialogue. Typically, this involves at least 2 or 3 meetings over a period of about 2 weeks. For example, a consultation process may look something like this. So you may have initially a collective at-risk meeting with all staff members that are affected. You may then have a one-to-one discussion with the employees about their role being placed at risk with a view to finding an alternative. And the final meeting may be one-to-one discussion, providing an outcome to each employee about the redundancy process, which may be the sad news of confirming the redundancy. It is also worth noting that additional meetings may be required through this process, depending on how the consultation meetings progress. But during the consultation meetings, what you should do is provide all the relevant information to employees or representatives, including answering any questions they may have. You should give them time to consider the information and respond, and also consider and respond to any alternative suggestions made. It's also important that redundancies are only considered as a last resort measure. Other steps should also be considered first to avoid the need for compulsory redundancies. So consultation should take place when proposals are at a formative stage, allowing for genuine input from employees. A failure to consult properly can render a redundancy dismissal unfair, even if the redundancy itself was genuine. So consultation shouldn't be seen as a box ticking exercise. What it should be seen as is a meaningful process which is aimed at exploring all options to avoid or minimize redundancies to ensure that the process, if necessary, is carried out fairly and transparently. So that takes on to when there's a situation of 20 or more redundancies in a 90-day period in a single establishment. So where there are more than sort of 20 redundancies in such an establishment, then you're required to notify the Redundancy Payment Service, or RPS for short, using form HR1. And that would be to notify them of the proposed redundancies before you start the consultation process. And the RPS is basically a government department. parts of the Department for Business. So what you'd be obliged to do is consult with the staff under the collective consultation rules. And as part of that, as I say, you need to notify RPS. If you don't do that, it could lead to penalties, including an unlimited fine. Now, what we mean by collective consultation is that you're required to essentially consult with trade union representatives, if any are recognized by your business, elected employee representatives, so just regular employees, or with each member of staff individually on the proposed redundancies, if there are no representatives. The consultation process would also require you to address any particular questions posed by the employees and formally set out the rationale behind the redundancy proposals. So again, just like with, if the situation with less than 20 redundancies, there's no sort of prescribed timescales in which collective consultation needs to take place. It just needs to be meaningful, just like the other situation. However, the difference here would be that the collective consultation process will need to begin at least 30 days before the proposed date of any redundancies if there are more than 20, but less than 100. But if there are more than 100, then it needs to be at least 45 days beforehand. And that means just notifying the RPS at least 45 days before the first redundancy can take place. So essentially, it is a timescale. Now, until the final consultation meeting, and this applies for both collective consultation rules and the situation where that doesn't apply, where there's less than 20 redundancies, it is important that staff are told that their position is only at risk of redundancy rather than it being a guaranteed outcome. Because if you state that redundancy is a guaranteed outcome right from the outset of the consultation process, it could mean that any consultation period is not meaningful and it could lead to claims for unfair dismissal. So very important in terms of the language that we use. So alternatives to redundancy. At the outset of a fair redundancy procedure and throughout the consultation process, you should consider whether you can avoid the need for making compulsory redundancies or reducing the number of compulsory redundancies. You should also consider during this individual consultation as part of a fair redundancy procedure, and initial steps that you should consider include suspending or restricting recruitment, reduction or removal of overtime opportunities, not renewing contracts of contractors if applicable, and ceasing or reducing the use of agency workers, again, if that's applicable. Now, if these initial steps are unavailable or are not sufficient, then you could consider inviting potentially redundant employees to apply for suitable alternative vacancies. So if you have any suitable alternative vacancies for employees, you must offer the employee an opportunity to apply for the role, particularly those that are at risk. Especially if you have a situation where you have an employee who's just recently notified you that they're pregnant or are due to return from period of maternity, adoption, shared parental, or neonatal care leave, because these employees in these situations will have a preferential right to be offered an available suitable alternative vacancy before those who have not returned from such a leave or have such a protected characteristic. Now, to determine really whether a role is suitable or not, then you need to look at various factors such as the employee's skills, experience, and the terms of the alternative role, such as the pay, hours, and responsibility. So, for instance, it's unlikely that an employee who was perhaps employed as an accountant and was offered a role as an administrator is a suitable alternative because that would be, very much different to the role that they were doing. If, however, a role is a suitable alternative and an employee unreasonably rejects it, then they will be treated as having been dismissed by you, but they will potentially lose their right to a statutory redundancy payment. Now, to determine whether an employee has unreasonably rejected a role, various factors need to be taken into account, such as the circumstances that the offer was made, the duration of the role, if that is, a temporary role, and the employee's personal circumstances, of course. Now, other alternatives to redundancy include layoff and short-time working, and layoff simply means that an employee is not provided with any work by you, and the situation is expected to be temporary. It's almost like a temporary redundancy. And during this period, the employee remains employed by you, but usually does not receive their normal pay, save for any statutory guarantee pay. Short-time working means that an employee's hours are temporarily reduced, and they are only paid for the hours that they work, in addition to any guarantee pay for any days the employee does not work. So in order to utilize either of these two alternatives, you must ensure that you have the contractual right to do this, or you will need to obtain your employee's consent. You should also be aware of statutory guarantees for minimum pay during layoff or short-time working periods, which is currently a maximum of £39 a day for 5 days in any month, 3-month period, which is currently around a maximum of £195. You should also remember that prolonged periods of layoff or short-time working may still result in redundancy claims. For example, if this occurs for more than 4 weeks in a row or 6 or more weeks in a 13-week period. So it's very important that you are still careful, even if you exercise these options. Voluntary redundancy. So inviting employees to volunteer for redundancy can also be an effective strategy for managing redundancies, and this approach can help avoid compulsory redundancies and potentially maintain morale among the remaining staff. Now, when considering this option, it's important to clearly communicate the terms and selection criteria for accepting volunteers to ensure transparency and fairness in the process, because often volunteers will receive an enhanced redundancy package. However, you should exercise caution when considering voluntary redundancies because there is a risk of losing key skills and experience if too many valuable employees opt to leave. Additionally, if it's not managed carefully, then this can inadvertently create age discrimination risks, particularly if it appears to target older employees or if the terms are more attractive to them as well. So though employees are volunteering, you still need to make sure that you carry out this process fairly, which means following a fair procedure, including consultation with the employee, and ensuring the decision to accept any voluntary redundancy application is based on objective reasons rather than arbitrary factors. You should also be prepared to justify your decisions if you challenge, particularly if you accept some volunteers but reject others. Now, a selection matrix is a very important part of any redundancy process, particularly where there is a pool of employees, i.e., when you've got more than one employee with the same role that is placed at risk. So, in these circumstances, you will need to prepare a matrix using objective factors, so factors that are measurable, and that would be based on things like performance and length of service. And the idea behind this really is that you score each of the employees that are at risk on each category, for example, 1 to 5, 1 being the lowest, 5 being the highest, and the lowest scoring employee or employees are the ones that are ultimately made redundant if an alternative can't be found. Now, any roles that are similar to those at risk should also be pulled and placed at risk. And common elements that are used in a selection matrix include skills, qualifications, and experience. It could be standards of work performance. It could be attendance, excluding any sort of pregnancy or disability related absences, and a disciplinary record as well. Commonly, commonly I'd say, but I'd say it's very common. Employers will rely upon a last in, first out rule, and the use of this rule as a sole criteria should really be avoided, as it may be deemed to be indirectly discriminatory younger employees. This is basically the last employee that joins the company is the first one that's made redundant. So just be wary of those risks because usually it's younger employees that have not been with you for that long. The matrix should also be applied consistently and should be kept a record of just to make sure we have sort of recorded exactly how the scores were allocated in case we're challenged. It is also worth considering using more than one person to score the employees and allowing employees to review and comment on their scores during the consultation process. Now, throughout this sort of consultation process, it is important to document your decisions and rationale. And as I say, it will help demonstrate the fairness of your procedure, particularly if you're challenged by an employee. And you should also consider seeking legal advice for complex redundancy situations, especially those involving large numbers or potential discrimination issues. Ultimately, whenever you have a redundancy situation, the onus is not only on you to find an alternative to redundancy, it's also on the affected employees as well. But the onus on you is typically greater as well. So, what are the main risks then associated with redundancy situations? Well, the primary risk is potentially a claim of ordinary unfair dismissal, and an employer will be eligible to bring such a claim if they have at least 2 complete years of continuous service with you. Now, for employees who have less than 2 complete years of continuous service, they would not be able to bring a claim for ordinary unfair dismissal. However, they may be able to bring other types of claims that do not have a prerequisite length of service, such as discrimination or contractual claims. While strictly speaking, a genuine redundancy is a defence to an unfair dismissal claim, often employers will make a mistake during the consultation process, which renders that dismissal as procedurally unfair. And a failure to carry out a meaningful consultation process could lead to a finding of unfair dismissal even if the redundancy, itself was genuine. So it's therefore important to document each stage of the process carefully and to follow it carefully as well, just to demonstrate fairness if you are ever challenged. With protected of wars, this applies essentially if there is a situation with 20 or more redundancies, i.e., where collective consultation rules apply. Now, if you do not sort of follow the consultation requirements, then employees can make a claim to an employment tribunal. And if that claim was successful, then you may have to pay the employee or employees compensation. And this is known as a protective award and can be up to 90 days full pay for each affected employee. Other risks include discrimination, so you should ensure that the redundancy process doesn't directly or indirectly discriminate against any employee on the basis of a protected characteristic, such as their age, disability, or pregnancy, or maternity status, and any other sort of protected characteristic. So you should really be particularly careful if you need to use a selection criteria and consider how this may disproportionately affect certain groups. For example, I mentioned earlier you should discount pregnancy-related absence because if you didn't, then they would be potentially indirectly affected by that criteria. Additionally, you should consider the impact of the consultation process on part-time workers or those with care and responsibilities as well. While there is also no sort of legal requirement to offer an employee the right of appeal in a redundancy situation, failing to do so may actually affect the overall fairness of the dismissal depending on the facts. So it's also worth noting that in some cases that a fair appeal process can actually remedy any earlier defects in the redundancy consultation process and fix those issues. So therefore, we'd recommend giving the employees the right of appeal when you confirm the outcome to redundancy. Now, the final steps. So this is essentially when the employee's role is made redundant, then you'll be required to essentially issue a formal letter setting this out. And this letter should cover a lot of different points. For example, it should clearly state that the employee's position has been made redundant and the reasons for that. It should confirm the employee's last day of employment and the redundancy package if they're eligible for one with a financial statement. It should explain how and when the final payment will be made, provide information on the right to appeal the decision, request the return of any company property if that's applicable, like a laptop, for instance. And it can also be used to remind the employee of any post-termination restrictions, such as non-compete clauses or confidentiality, again, if that's applicable. Sometimes employers also like to thank the employees for their service as well to the company and agree to provide them with a reference. So you can also look to do that as well. Now, when it comes to pay, employees who've had the employment terminated by reason of redundancy will potentially have an entitlement to a statutory redundancy payment based on their age and length of service. But this is conditional on the employee having at least 2 years of conditional employment, with continuous employment with you rather. Now, for employees with less than 2 years of continuous service, there is no automatic right to a statutory redundancy payment. When it comes to the calculation of redundancy pay, statutory redundancy pay that is carried out as follows based on half a week's pay for each full year the employee was under the age of 22, is 1 week's pay for each full year the employee was age 22 or older, but under the age of 41, and 1.5 weeks pay for each full year the employee was age 41 or older. So that's a statutory calculation that can be used. Now, there are limits on redundancy pay as well. For example, length of service for the purpose of calculating pay is capped at 20 years, and a redundancy payment is also paid at an average of an employee's basic pay, weekly basic pay that is, over the 12 weeks before the day the role was made redundant. And this is capped at a maximum amount of £719 per week for any redundancies that took place after the 6th of April this year. So, for example, if you had an employee that was age 25, they had 2 years of service and earned £1,000 per week on average, they would be due 2 weeks statutory redundancy pay. But due to the statutory cap, their redundancy pay would actually be £1,438 as opposed to £2,000. But if you had the same situation with another employee who earned £400 per week on average, then their pay would actually be £800 as this amount falls below the statutory cap. And this cap that I mentioned as well, it does usually change every single year in April. So it is something to be mindful of depending on when the redundancy takes place as well. Additionally, if bonus or commission payments are paid regularly, this may also impact the employee's average weekly pay and consequently any statutory redundancy payment owed to them. Finally, it's worth mentioning as well that statutory redundancy payments are actually payable tax-free up to £30,000, though it's worth noting that the current maximum statutory redundancy payment is £21,570. Contractual redundancy pay. So this isn't really a legal requirement, but some employers like to offer it as a bit of a benefit, and typically it's more generous than the statutory minimum. And it can be based on various things, but it can be set by the company itself and can be set out either in the employee's contract or a redundancy policy. Typically, these types of schemes may offer uncapped payments, higher limits, or be calculated differently to statutory payments altogether. And sometimes it's also paid in addition to statutory redundancy pay, but some schemes may incorporate the statutory amount into the contractual amount as well. Now, the taxation of redundancy pay can be quite complex with different rules applying compared to statutory redundancy pay. And due to these complexities, we would recommend consulting with an accountant or your payroll team for specific advice on your situation. Or if you would like to use the complimentary consultation with us at the end of this webinar, then feel free to reach out to book in a call with us through that method. Other payments that need to be considered would be things like the employee's notice pay or a payment in lieu of notice if you have the contractual right to do this, any accrued but untaken holiday pay, any wages up to the point of termination, and any other payments like expenses, commission, or bonuses if they are applicable. Now, these payments, unlike the statutory redundancy payment, would be taxable as normal, and all of these payments should be made when the employee's employment ends or on your next payday. A final payslip should also be issued to the employees as well as a P45. So that now concludes the main part of our webinar, but you might find our publication on how to hire and inspire in the UK useful, and that can be downloaded using the QR code shown on the slide. We also have an upcoming event that may be of interest to you. So our next webinar is on employee and contractors, and that's talking about protecting your business from costly status mistakes, which will be on Tuesday, the 6th of May at 11 a.m. BST, and you can register that at the link shown on the screen. Now, we're going to answer your questions shortly, but while you submit them, we'll take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business essentially gets entitled to unlimited access to our team or specialist lawyers for all your business as usual legal needs. It's essentially like having your own in-house counsel for a fraction of the cost. So our team can assist you with lots of different things, such as unlimited document drafting and reviewing a business contract, unlimited legal advice consultations, so that includes employment and HR advice, and unlimited domestic trademark registration, and much, much more. As a LegalVision member, you won't need to worry about the cost of lawyers again. As I say, it's like having your own legal in-house counsel, and we'll take care of all the business as usual legal work so you can focus on running your business. And if you are in-house counsel, we also offer a dedicated service to manage your high volume business as usual legal tasks. To learn more about our membership or desk extension and how this can help you, please request the free consultation when the survey appears at the end of this webinar. And now we'll move on to answering some of your questions. So just going to have a quick look at the questions that have been submitted throughout this webinar. I can see one was actually submitted beforehand. It was about, I guess, the question is regarding insolvency and what insolvent employers should do if they can't sort of afford to meet the payments. So what I would say when you have any sort of situation similar to that, would be that firstly, the company is still responsible while it's still solvent. It's only once they're insolvent where they can potentially discharge some of their liability. Now, while the entity exists, you're still liable. But if you instruct an insolvency practitioner, then what would happen is typically they would contact each of your employees to let them know the situation and issue them a document. And what they would do with that document, it would have a number on there, which is called a CN number, and they can use that to apply to a government department, the RPS that I mentioned beforehand, the Redundancy Payment Service, and they can claim the redundancy payment that the insolvent employer can't afford to pay from the government directly. Additionally, if the employer cannot afford to pay other payments, such as notice pay, wages, holiday pay, the employers can potentially claim that from the RPS as well, using a different reference number called an LN number. But as I say, this is only applicable for genuine redundancy situations where there is an insolvency practitioner involved and there is the CN number initially, followed by the LN number, if that's applicable. So I hope that answers your question. So I can see another one's just popped through as well. So let me a quick read of that. So is an employee made redundant after the normal retirement age entitlement to a redundancy payment? So that's a very good question. So in terms of when it comes to redundancy calculation, it gets capped essentially when someone has more than 20 or more years service, but equally it gets capped when they're over the age of 61. But even if someone goes over the sort of statutory retirement age, if we say, so which is around 66 or so at the moment, depending on when someone was born, ultimately, there's no legal requirement for an employee to retire if they don't want to. If they continue to work, and then ultimately the role is later made redundant at, let's say, 70 years of age, then you would just basically calculate the redundancy payment based on the age and length of service. If you have a situation where they decide to retire later on, then they wouldn't be entitled to a redundant situation there because retirement doesn't have any sort of special status. It's treated like a resignation. So unless there's a redundancy situation, they wouldn't be entitled to any redundancy payment. So I hope that answers your question too. I'm just going to see if there's any more questions. Okay, so there's another question here as well. It says, what if an employee earns more than £719 per week? So that's a good question. So the £790 per week is the statutory cap that applies from the 6th of April this year. So if any redundancy is made after that, if someone earned more than that, let's say £3,000 per week, and they were entitled to a redundancy payment, it would unfortunately be a situation where their payment would actually get capped at the £719 per week. So even if they earn the two, three, £4,000 per month, or per week rather, then it gets reduced down to that level. So it'd be a statutory cap. It's set by the government. So there's no sort of way around that. The only way, I guess, to consider around that would be if, the employer offered a contractual redundancy policy where they may set their own rules. So I hope that also answers your question. I think there's time maybe perhaps for one more question. So we've got one here that says, are employees with less than 2 years service eligible for any payment? So again, another good question. So employees with less than 2 years service, you might have realized, they're not entitled to a statutory redundancy payment, but that doesn't mean they're not entitled to any payments at all, because as I mentioned beforehand, sometimes an employer may offer a contractual redundancy pay. It's not a legal requirement, but some employers do like to be generous and offer that. Another sort of payment they may be owed would be the notice pay or a payment in lieu of notice, because that's still a contractual right, along with any other contractual payments like their holiday pay, their sort of wages up to the point of termination, any bonus, commission payments, and that sort of thing as well. So you get the idea that ultimately, there are still contractual payments that still need to be paid to those employees as well, even though they have less than 2 years of service. So I hope that answers your question too. I think that is actually all of the questions. So excellent. So that is all the time that we have for today. But after the webinar ends, a survey will pop up, as I mentioned. So we would really appreciate it if you could complete the 30-second survey. Please also remember to include your contact details to receive a complimentary legal consultation to discuss how we can help you with your employment contract and key clauses to protect your business, along with any other HR queries that you may have. So once again, from me and the team at LegalVision, thank you very much for joining us, and we hope to speak to you soon.